Divorce Talk Radio does not give legal advice, neither does it reflect the views of Rockford College. To obtain legal advice, you need to retain an attorney in your own jurisdiction. Good evening, folks, and welcome to Divorce Talk Radio. This is attorney Brad Tengler here in the studio with Jeff Carter to talk about child support and some custody-related issues. Today we're going to be receiving some call-ins as well as people who are texting us or sending us Facebook messages about child support questions. To begin with, Jeff, do you have any questions for me?
Sure. With child support, how is it determined?
Child support is based in Illinois off Section 505 of the IMDMA, the Illinois Marriage and Dissolution of Marriage Act, and there's basically a formula. It's rather mathematical for determining child support.
Okay. Now, how can it be changed?
Well, child support, once it's established, can only be changed if there's some kind of change in circumstances. So let's say you get fired from a job, you get a different job, something along those lines. You can petition the court to have it modified down. On the flip side, if you're receiving child support and your ex gets a better job and is getting paid more money, they can petition the court to have child support modified up.
Now, when does child support initially stop then?
Child support will continue throughout the entirety of a child's minority, so up until the age of 18, 19, when the child graduates from high school. After high school, there are provisions in the code for a different type of calculation for college-related expenses, but child support proper stops when the child's out of high school.
All right. Okay, Brad, I have another question for you. In some situations, just like myself, I was raised by my grandparents because both my mom and my father did not want to take on the responsibility or whatever reason they had, and I'm not going to go into that completely, but whatever reason they had. Now, how does that work? Do they both have to pay the grandparents that took custody then, or how does that work with grandparents or like an aunt or anybody really, I guess, could have custody as long as they have state approval, correct?
That's a good question. In a situation like that, I'm not sure what the situation was with your grandparents. However, perhaps your grandparents petitioned the court for guardianship in probate court. Neither your mom or dad at that time were able to, fully raise you, so your grandparents raised you. If they petitioned for guardianship, then they could have proceeded to get child support from both your mom and your dad as guardians, since they were your guardians.
Okay. Now, are there some situations that maybe, let's say, I'm guessing there's some people that really do have a decent amount of money when, like the father or mother, whoever has custody. Are there other ways that you can work out a situation where you pretty much just pay a lump sum of child support where you don't have to pay monthly? Is there a way that, let's say, I'm a millionaire or whatever, can I just say, okay, well, how about I just make you this one offer and I just pay you some odd amount of money instead of me paying you monthly? Or it won't change. Is there non-fluctuating child supports too as well, like where you just have a one lump sum, like one amount, where if you lose a job or you don't lose a job, you get a better job, and we already have it in written statement that it's just going to be this amount of money until the kid's some odd years old.
Okay, let me go back to the lump sum question first. Sure, I could imagine a situation where a judge approved that kind of order. However, it is very, very, very rare. Rare for two reasons. One, because first of all, people generally don't have that kind of money. I mean, if you think about a child being, 6 months old and someone having to pay child support up until the age of 18 months, who has that kind of money to pay 18 years of child support all in one lump sum payment? So that's one of the issues. Secondly, let's say someone was trying to get out of paying their full child support and they just want to make a lump sum payment of $10,000. It seems unlikely that the other side would agree because over an 18-year period of time, it's going to be much, much more than $10,000. Or, someone might get a better job in the future, and they might be entitled to a lot more child support, but which they didn't realize at the very beginning of the child's life. Later on, someone gets a $150,000 job. Obviously, that person's going to be paying more child support. So usually how child support works, almost always, is You just follow the percentages under that section of the code, section 505. One kid, it's 20% of net income. Two kids, it's 28%. Three children, it's 32%. So, and it goes on from there.
Sure.
But you follow those percentages on the basis of net income.
Okay. Now, I know this is kind of similar subject right here, but involving taxes. A good friend of mine asked me, the child is, going on 2 years now, and doesn't get any financial help, any help whatsoever at all for the child. And she claimed well, this is the first time she claimed him. He will be 2 next year. So her question to me was, well, now the father of her child just got a job now and is still not trying to pay child support at all. How does that work? Because he's saying that, well, you're gonna have to let me claim the child next year, even though he's not still gonna help out hardly at all, but he's gonna be on payroll. How does that work exactly? Is this true that now if you're both on payroll, no matter how much you help out, it's every other year? Is that true?
Very good question. Every child support related issue should be addressed by a court order. Why? For the very reason that you're asking me this question right now, so people don't fight about it in the future. If you don't address every child support related issue, then someone's going to be upset, or someone's not going to be being paid, or someone is going to have a ton of expenses which they didn't realize they were going to have. An example, uncovered medical expenses, meaning medical expenses not covered by insurance. If no one expects that, little Johnny, when he's 6 years old, is going to have heart surgery, but he ends up having heart surgery, and even if you've got great insurance through, say, Blue Cross Blue Shield, you still might have a debt of, $25,000 or $50,000 or something like that if it's a $250,000 surgery. So who's going to pay that? If the order doesn't specify who's going to pay that, then probably the custodial parent is going to end up being the person who has to initially, fork over that money to the hospital or to the surgeon, and then there's no order making the visiting parent pay any of that money. So that's something that needs to be addressed in a court order. With claiming the children on taxes, same thing. You should have that laid out. Generally speaking, what happens is, let's say you've got 2 kids. Mom has custody. Dad's the visiting parent. Dad is paying child support. Usually court orders say something like this. The custodial parent can claim child A. The visiting parent can claim child B, as long as the visiting parent is up to date on his child support.
Okay.
So if he's paying his child support, mom is already, if mom's the custodial parent, she's already got the major financial burden because she has the children most of the time. But, dad's paying his child support, so he gets to claim the child every year, or one of the children every year, and mom gets to claim one of the children every year. If they've only got one kid together, then every other year they get to claim, each person gets to claim the child as long as the visiting parent is up on his child support.
So I guess my question is how does it really work with a lot of people now that either sell drugs for it could be mother or father, I guess, but for a lot of these situations, at least for people I know, they don't have a job on payroll, whatever, and what's the I'm trying to think of the right terminology, but what's the way to go around to get child support if the person you had a kid with is not paying you at all and doesn't have a job? I mean, what's their way of eventually getting money? Because doesn't they eventually go to jail? Is that how it works now, or is it true they have their taxes forfeited because they're not paying during the year? I mean, there's a lot of different ways of asking this question. I'm just trying to think the right one.
So you're meaning the visiting parent is getting money under the table, like maybe he's
right.
a bartender and gets tips, or I think you mentioned illegal activity,
right? Exactly.
Where he's getting a ton of money from doing something illegal,
right?
But he's
and
still
not paying you either,
money.
And not paying the other person whatever amount of money.
That is actually pretty tough. Even as attorneys, it's tough for us to figure out how to determine or how to prove when someone is getting money under the table. Let's say someone's a bartender and they get paid minimum wage bartending, or less than minimum wage. I think it's less than minimum wage bartending, but they make $200 a night in tips.
Okay.
But they're only making $50 a night on their W-2.
Okay.
So we get their W-2s for the entire year, but that's only 1/4 of their income for the entire year. How do we determine what their actual income is? That's pretty tough. I mean, one of the ways I think to do it is to look at their expenses. If they're renting an apartment for $700 a month, if they have a car payment of $300 a month, if they are paying for their food and their cable and their cell phone for another, $500 a month, you can do the math on that and say, okay, your W-2 doesn't add up to what your actual income is.
Right.
And then when you get in front of the judge, you can say, Judge, he's saying he's a bartender. He only gets, this amount, but based on his expenses, it's only about 1/4 of what we know he's actually being paid because he has all these expenses. That's one way to do it.
Okay.
And we can get access. We can subpoena records. We can subpoena, what his lease would be, and we can subpoena bank accounts. Obviously, if people are not putting cash in their bank accounts, that's only somewhat helpful. But still, it's helpful if we know what their expenses are.
Okay. I also have somebody that texted me. I might as well just ask you instead. This person wants to remain anonymous. Is that
Sure.
fine with you?
That's fine.
My daughter is 11 years old and wants to live with me. She is with me about 80% of the time. And the only reason she is not with me full time is because her mom still wants the child support money, which is not court ordered. I've been paying child support by check every 2 weeks since my daughter was 4 years old. So I guess I have two questions. Can a judge come after me for back child support if she ever takes me? And two, is there an age where the child can decide to live with a parent? My daughter tells me she sees different things done in front of her, illegal things, and also the mom and boyfriend do illegal things in front of her as well, and just I want my daughter out of that situation, but I want to find the right answers to make it happen.
Okay, let me break down some of those questions. And first of all, clarify some of the facts. So first of all, his daughter is living with him. That's correct, right?
Well, let's see. She wants to
daughter
live 80% of the time. She is, yeah.
So 5 nights out of the week, 6 nights out of
Right.
the week, daughter's over at dad's house.
Sure.
And so even though by court order, mom is the custodial parent, dad is functioning as the custodial parent, right?
Okay, yeah.
Okay. So that's the factual situation, and then he wants to know if mom can come back after him for child support since there's a child support order set in place.
Well, right. Now, it says,
Absolutely yes is the answer to that.
Okay,
If there is a child support order set in place,
okay.
even though the child is living with dad 80-90% of the time,
Uh-huh.
doesn't matter. The child support order says he's got to be paying child support. And so, as generalized kind of information, generalized information, he needs to get into court and
Okay.
he needs to modify that child support order.
Yeah, because
If
it
he-
says it's not court order, is what he's saying. It's not court order for the child support.
Well, if there's no court order, that's different.
Okay.
If there's no court order, then mom could petition for child support, but then testimony is going to come out that 80% of the time the child was living with mom. But if there is a court order giving mom custody, and if there is a court order saying that he needs to be paying child support, even if the child's living with him, most of the time doesn't matter. He's got to
Okay.
get into court. He's got to petition the court to stop his child support, and he's got to petition the court to modify custody.
Okay.
So, did you say this guy currently there is a custody order set in place?
Well, again, I'll just read it one more time. It says, my daughter is 11 years old and wants to live with me. She is with me 80% of the time, and the only reason she is not with me full time is because her mom still wants the child support money, which is not court ordered. I've been paying weekly child support by check every 2 weeks, or excuse me, not weekly, paying child support every 2 weeks since my daughter was 4. So I guess I have two questions. Can a judge come after me for back child support if she ever takes me?
Well, there's no court order about child support right now. Judges can make determinations about that, but he's not going to be held in contempt if he's not paying child support right now because there's no court order.
Okay.
So he can't be held in contempt.
Okay.
But then it sounds like he's got another question about he wants custody of his daughter.
Right.
Sounds like a perfect situation for him to get custody of his daughter.
Okay, yeah, definitely.
Obviously I don't know all the surrounding facts in the case. I don't know, what his background is. I don't know if there was any criminal activity that he was ever engaging in or anything like that. But it sounds like this is an ideal situation. Dad has obviously stepped up to the plate. He's acting as the custodial parent. Mom, based on his representation, has all these kinds of issues. Daughter is living with him. It seems like an ideal situation for him to get custody, but he's got to petition the court for custody.
You know, one thing I have a question off the top of my head. It seems like for a long time I've been hearing, it seems way harder for a father to get custody. I don't know if this is true or not, but it seems like if they have a full-time job and you're fighting against a female, it seems like a lot of times the female gets the custody due to the fact that, you know, you're proving that you work full time. It's hard for you to find babysitters or whatnot, whatever, raise a child correctly if you're working 40, 60 hours, whatever it is a week. That happened in my situation. That's why my brother and I was with my mom, because she didn't have a full time job to be able to pay him. So that's pretty much what we were told why we ended up with my mother. But is that still true? Or I mean, it seems more hard for the father to get custody.
Okay. The law does not favor either men or women when it comes to custody, okay? All things being equal, either parent can obtain custody, and the law does not favor either the mom or the dad.
Okay.
That being said, there's some practical concerns. For instance, you know, you've got an infant who is breastfeeding.
Okay.
And everything else being equal, mom's a good mom, dad's a good dad.
Right.
If the child's breastfeeding, it seems rather logical that mom should have custody. I mean, you know,
Certain
sure you can make an
right.
argument against it if there's other issues going on, but that seems kind of logical. If one of the parents is employed full time and the other isn't, whether it's the mom or the dad, it probably seems likely that the parent who's not employed full-time, i.e. the parent who is already engaging in child care, is probably going to get custody and then, you know, is entitled to child support. I mean, that makes sense.
Okay.
If you want custody of a really younger child and you are working 80 hours a week, well, who's going to take care of the kid? Mm-hmm. Your parents? Well, that's not you being the custodial parent.
Okay.
And that cuts across gender. I mean, whether it's the mom who's working 80 hours a week or dad who's working 80 hours a week, it seems logical that the parent with more time is and has already been around the child or children more often. Seems like the logical choice for custody, everything else being equal.
Well, I'm guessing there's a lot of things that can make that, like you said, a background in either case, a mother or father, I'm guessing could make a big difference and a deciding factor as well then. I mean, because if the mother has whatever problem in the past, if it's child abuse or if it's drug abuse or whatever, then that obviously will make a major decision on the judge anyway.
Huge. Yeah. I mean, if we have a mom who has been indicated by DCFS for child abuse, or if we have a mom who's got a major substance issue, regardless of whether or not she is the stay-at-home parent, that's going to have a huge effect on the judge's determination of custody. Obviously, you've got to prove that stuff.
Okay.
You know, people come in to court all the time and say, "Oh, that person's got a substance issue." Well, allegations are not the same as proving things.
Okay.
You got to prove it. I mean, maybe they had a substance issue 5 years ago, but they cleaned up.
Right.
And if they cleaned up, then that's a different situation.
Of course.
People change, people become better people, and then they're able to, you know, function better as parents.
Okay, I got another person that texted me a bunch of questions, so
sure.
This is definitely be good. What is full custody from a legal standpoint, and what are the rights and responsibilities for full custody?
Full custody. We just did a blog about different types of custody. There is sole custody. There is joint legal custody with one of the parents having primary physical custody, and then there is joint legal and joint physical custody. So I'll go back to the first one. Full custody, I think you might be referring to sole custody. Sole custody means that one of the parents has the sole right to make the legal decisions about the child as well as the day-to-day care decisions about the child. So when I say legal decisions, I mean education, religion, and medical.
Okay.
So if the custodial parent is the dad and he has sole custody, then he can make those decisions without coming to an agreement with his ex-wife or his
Okay.
ex-girlfriend. Physical custody refers to the ability of the parent who has physical custody to make decisions about day-to-day activities for the child, which makes sense. If dad has primary physical custody and he's getting the kids up for school every day and getting them to school and getting them to the doctors, then he needs to be able to make those decisions without, getting permission from mom every day for when they wake up and when they go to school and things like that. Now, that doesn't mean that the other parent doesn't have the right to be informed of some things, like, hey, parent-teacher conferences. When are the parent-teacher conferences? Or the visiting parent might not have a right to make a decision about who the primary care physician is of the child.
Doctor,
but
right.
when are the doctor appointments?
Right.
And having access to that information.
Sure.
So there's a difference between access to information versus having the right to make decisions about doctors and teachers and things like that. So that's sole custody. Go ahead.
Oh no, I got a bunch here. Okay, that's full custody then. Then what exactly is a joint parental agreement then?
A joint parental agreement. I think he's getting at something like joint legal custody.
Okay.
Okay. If parents have joint legal custody, let's say mom is the primary physical custodial parent,
Okay.
but mom and dad have joint legal custody. If they both have joint legal custody, that means three things. First of all, both of the parents have the right to make decisions about three major things: religion, education, and major medical. And there's a process for that decision-making process. Usually it is talk about it first. If that doesn't work, go to mediation. If that doesn't work, then litigate.
Okay.
By litigate, I mean file a petition.
Sure.
So it keeps people out of the courtroom before they've done the other two steps.
Okay.
And they got to talk about it. They got to try to work these things out. However, joint legal custody only works when the parents can communicate well. So if you've got parents that are constantly fighting, they're still mad at each other from their past relationship, and they're making it affect how they raise their children, joint legal custody probably isn't going to happen. The joint parenting agreement that the guy who messaged you
Sure.
mentioned is something that is put in writing that both parties can look at for the guidelines of how they're going to deal with education, religion, and major medical.
Okay.
What's the process? What are we going to do? What are we not going to do? What's the promises I'm making to you? What are the promises you're making to me? Things like, I'm not going to talk bad about you in front of the kids. If I have a problem with you, I'm going to talk to you about it, privately. I'll give an example. One time, there was a case where the parents were probably about to engage in a custody battle, which is always very emotional. But I noticed in some of the emails that they did a really, really, really good job at talking to each other about how to discipline their child without their kid getting involved. So, Johnny did X. Dad shot mom an email that said, hey, Johnny did X. I think the punishment should be this. What do you think?
Right.
And then mom emailed back and said, hey, this is my idea. And then they came to an agreement. That is a perfect example of joint parenting.
Okay.
They're keeping it out. They're keeping the issue away from the child. They're unified in what they're going to do as a discipline for the child. And, they're being really respectful to each other, which I thought was really impressive, considering that there was potentially a custody battle that was about to happen.
Let's see.
And I know we're off the topic of child support, which is fine.
Oh, okay.
Which is fine. These issues are
Okay.
obviously child support is connected to who has custody, but
Right. Okay. How much does it cost let's see. How much does it cost, and do you really need a lawyer to obtain child support?
Okay, I'll talk about the first question. The first people always ask me that when they come to my office.
Sure.
and I do free initial consultations, and they come down and say, well, tell me what this is going to cost me. And I say, well, this is my retainer. This is the amount of money that people give to me up front, but I'm not going to answer that question. The total cost of any litigation depends on the parties.
Okay.
If one of the parties or both of the parties are unreasonable, it can take a case that could have cost $1,000 and make it $10,000.
Wow.
Or a case that could have cost $10,000 and make it $30,000.
Holy Moses.
If people fight about everything under the sun and cause all kinds of problems for each other, that just means there's going to be more paperwork that's filed, more times we're in court, and doesn't necessarily mean that there's going to be any better outcome.
Sure.
If people are fighting all the time, it's a lose-lose situation. So total cost is completely unanswerable. It depends on whether you can get along with your spouse, your ex-spouse, or your ex-girlfriend or boyfriend,
whatever,
and or whether they can get along with you. I mean, sometimes I have the nicest client in the world, and the person on the other side is unreasonable. Sometimes my client's unreasonable, and so if both parties cannot learn how to communicate with each other, it can cause a lot of cost for litigation. So that was the first question, and I forget the second question you asked me.
Sure. The money was the first thing. The second thing is, does somebody really need to have a lawyer to obtain child support?
I always say when a potential client asks me that question, that is up to you.
Okay.
Does having a lawyer help? Absolutely. We know the law, we know the courtroom, we know how things work, we know how to draft documents, we know what documents to send to employers and things like that. Absolutely. We can help streamline the process. We know the mathematical formulas for figuring out child support. All those kinds of things are really helpful. However, I've had cases where I try to do a cost-benefit analysis for my clients and say, listen, if he is making, if let's say the mom comes to me and she's the custodial parent,
okay,
and dad's making a minimum wage job, it might be better just for her to go into court. One of the great benefits that we have here in Winnebago County is that the Attorney General,
okay,
if you are on Medicaid or receiving support from the Department of Healthcare and Family Services from public aid, they will petition for child support for you.
Oh, there you go.
So they draft the petitions. Now it takes a while. I'm not sure exactly how long the process is, but they send you a letter asking you for your information, asking for who you think the father is, if it's the mother who needs child support. Then they file a petition to intervene, and they file a petition to establish parentage and child support. And so that's great, because then you have an attorney that's basically representing you for child support, and they'll send out a notice to withhold to automatically have the child support garnished from the visiting parent's wages.
Okay. This next one is kind of crazy. If a man signs an acknowledgement of paternity and is placed on child support for a child which DNA later concluded was not his, is there anything the father can do? These are one of these fun questions you like to answer.
This is a really interesting question.
Sure.
Voluntary acknowledgments of paternity were enacted by the Illinois legislature a long time ago when we had issues with, and obviously we still have issues with deadbeat parents.
Of course. Lots of them.
But maybe in the 70s it was more deadbeat dads, maybe. Now we can have deadbeats on either side. And so what they were trying to do, I think, was to prevent litigation in the future when someone is all of a sudden saying, that's not my kid, that's not my kid.
Right.
So you're in the hospital, you're standing there beside your girlfriend, and they give you this document, a voluntary acknowledgement of paternity, and you can either sign the document and waive DNA testing, or you can choose DNA testing. And that right to DNA testing on the VAP, on the voluntary acknowledgement of paternity, has to be bold, it has to be in all caps, it has to be very, 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 very large and readable. So when you sign that, after 60 days after signing it, it is almost impossible to get that vacated. That in itself is it's like a judgment of paternity. Simply by signing that document and waiting 60 days. There are some exceptions: fraud, material mistake of fact, or duress. Like if your girlfriend's laying there with a knife in her hand saying, if you don't sign this document, I will cut you.
Right.
But not if she's sitting there and saying, you better sign this document, and she's shaking her finger at you. That's not duress. That's, you still made a decision to sign that. So it is really hard, once you've signed that document, if not impossible, to have that vacated. So the point is when you're in the hospital, standing beside your girlfriend, and you're 5% unsure whether that child is yours or not, ask for a DNA test. Don't sign that document unless you are 100% sure that that child is yours.
Absolutely. Now, this is kind of a custody question, but what rights do mothers have if they gave birth to a child and never took the father to court? Example, is she required to allow visitation with the father, or does the father have to get that in a court order?
Say that last part again.
Sure. I'll just read the whole thing real quick.
Right.
What rights do mothers have if they gave birth to a child and never took the father to court? Example, is she required to allow visitation with the father, or does the father have to get that in a court order?
If the father has not signed a VAP, and the father has not been adjudicated by the court as the dad, then he is not the legal father.
Oh, okay.
He does not have rights to visitation.
Unless it's like a verbal agreement then.
No.
Not even.
No.
I'm saying, well, he can still ask her if he can see, obviously.
Yeah, but that's different than having a right to see the child.
Okay.
Now,
okay.
if he signed a VAP, or he's been adjudicated by the court as the father, then he does have legal rights to parenting time and to petition for custody. But until there's an adjudication of paternity, he is not the legal father of the child, and therefore does not have visitation rights under Section 607 of the Illinois Marriage and Dissolution of Marriage Act. But if he has, then he has a right to visitation. So mom shouldn't be withholding the child if he's done what he's supposed to be doing.
Wow. Okay. This is definitely things you need to research before you go ahead and go to court or skip court. Wow.
Or before you sign
anything.
Documents.
Right, yeah, definitely.
Facts.
Definitely. This is kind of a random question from another female friend of mine. How do you get your back pay from another state? Because this person had a child in Missouri, and the Missouri court is saying that since she moved back to Illinois, she doesn't have to get back pay. Do you know anything about that? Can you answer that question?
Well, first of all, I'm not an attorney in Missouri,
right.
So I don't know Missouri law. Secondly, that's probably something that has to take place through Missouri.
Okay.
If there is a Missouri child support order, then the Missouri courts have the ability to enforce it or not enforce it. Obviously, it's much more difficult if she's living 7 hours away from St. Louis, where the child support order was set in place. Means that she's going to have to show up in court every time, or she's going to have to get in a lawyer, which could be expensive.
Sure.
But if it's a Missouri court order, it generally has to be enforced through Missouri. Now, there are ways in Illinois, because the Attorney General, through public aid, enforces these orders in Illinois. And that process, there can be ways to enforce out-of-state court orders.
Okay.
And she should come to my office to talk to me about that if she wants to talk about enforcement in Illinois. But it's a complicated process.
Okay.
Where does this guy live, by the way? Illinois or Missouri?
He lives in Missouri, I think St. Louis.
Okay. Well, if he lives in Missouri, then she's definitely got to go down to Missouri to get this taken care of. Because Illinois isn't going to have any jurisdiction over him. He doesn't have any property up here. Missouri can attach his income tax returns. They can attach other assets that he has. That's going to be the jurisdiction that needs to handle getting child support for her if he is living in Missouri and there's a child support order in Missouri. Illinois really doesn't have anything they can do.
What about, let's say she really enjoys you as an attorney. Can she bring you down to defend her in Missouri, or do you have to do like
no.
There's no way you can?
No.
Okay.
I'm not barred in Missouri.
Oh,
Plus,
okay.
For me to travel down to Missouri, for her to pay me to travel down to Missouri would cost thousands and thousands and thousands of dollars just in traveling.
Okay.
And I'm not barred there.
So I didn't know how that worked. Okay.
find an attorney whose office is 5 blocks from the courthouse, wherever that courthouse is in Missouri, and use him or her to take care of that case.
Okay, well, there you go. There's the answer. Okay, Brad, I guess I have another question that's kind of similar to the cost of a lawyer, but this one's a little different, and the question is, how much should a father expect to spend on lawyer fees if he is seeking full custody of a child or child's children?
Another good question, which is largely unanswerable, but I'll give you a generalized picture.
All right.
Child support cases generally are a lot less than a full-blown custody case. Why? Because custody cases, you've got all kinds of experts. You are definitely going to go to trial for child support. There's a mathematical formula that you use to determine child support. With a custody case, there is a best interest analysis with factors under what constitutes best interest. And so if you have a full-blown custody trial, it is going to cost thousands and thousands and thousands of dollars. It could cost $30,000 for a custody trial. Plus, you, as well as the other party, have to pay half of the retainer for guardian ad litem. Guardian ad litem is an attorney that the court appoints, in custody cases to represent the best interest of the child. That attorney's got to be paid. How does that attorney get paid? That attorney gets paid by getting some money from mom, some money from dad. Usually it's 50-50, but if, say, mom makes twice as much as dad, she might pay more of the guardian ad litem fees. But again, that gets calculated into the cost. In addition, experts. Let's say there's a child psychologist or a custody evaluator.
Okay.
Custody evaluators are, often not used, but sometimes they are. And if they are, that costs thousands of dollars in and of itself. So if you're really serious about custody and the other side is serious about keeping custody, it's going to cost someone a ton of money. Now, obviously, there's many exceptions to that.
Sure.
I've had cases that began, and I thought they were going to be really contentious, and they ended up being really agreeable. Both the parties agreed that custody should be modified. Mm-hmm. Maybe we have like a 15-year-old who's out of control in mom's home, and both parties agree that the child should be with dad. Well, that case isn't going to cost a lot of money, probably, because both parties agree that it's in the best interest of the kid that custody be changed to the other parent. But again, we have an agreement there.
Okay.
And at the beginning of a case, you never know. There's ways to help the process to get people to agree, but you never know. And when you don't know, I usually tell clients it can cost you thousands and thousands and thousands of dollars, and you need to be prepared for that.
I'm looking at more of these questions, and there's a lot of them coming in. Okay, the next question I have from somebody is asking me, can I move out of state without the father of my children's permission?
No.
No way? Even if there's not... let's say he's not paying child support and there's no court order or whatever, you still have to ask permission, or you have to have permission to move?
Well, let me clarify that.
Okay.
You have to have permission from the court. Under Section 609 of the Illinois Marriage and Dissolution of Marriage Act, it is a criminal act, even if you have custody, to remove a child from the state of Illinois without leave of court. How does the court make a determination of whether it's okay to have a child be removed from the state of Illinois? If it's in the child's best interest.
Okay.
And there's a bunch of factors for making a determination about whether it's not in the best interest of the child to be able to leave the state of Illinois. But obviously this is a huge issue. Let's say mom has custody, mom marries again, and dad loses his job. He does not have any job opportunities in the state of Illinois. He gets this great job opportunity in St. Louis, takes the job. Mom still cannot move with the child until there's an agreement by the parties or by leave of court. So that can end up being many, many days in court as the judge makes a determination about whether or not he should let that happen or she should let that happen.
Can somebody take, let's say, the mother or father, can somebody take them to court? Let's say they owe you back child support, let's say you owe me back child support. Can I take you to court or to sue you for that? Can I take? Hey, you know what? You owe me some odd thousands of dollars. Can I take you to court for that, or does it have to be child support court the only option?
Child support court really is the only option, and it's the best option.
Okay.
The reason being is the child support court or the family courtrooms are familiar with dealing with those kinds of situations. If someone owes something like $10,000, $20,000 in back child support, you can go into court, you can bring that issue to the judge. There can be a calculation of exactly how much the arrearage should be, and there's over 9% interest on the arrearage. So if it's just $10,000 in back child support, it's plus it's 9% interest every year.
Ooh, wow.
Yeah. So do the math on that.
But how many people actually pay that back, though?
It depends. If the guy who owes child support is a worthless bum that doesn't have a job,
that's the majority of the time.
you're not going to get that money.
Right.
Or maybe you will in 10 years if he decides not to be a worthless bum and get a job. But if he has money, you know, if he's got like stocks or he's got a house,
they
or
seize
if
all
he's
that.
got, you know, a big bank account, you can attach those assets.
Oh.
Or in some situations, you know, they might twist his arm to make him take out a loan. I mean, for failure to pay child support in Illinois, the Secretary of State can take your license.
Wow.
For being held in contempt for failure to pay child support, you can be put in jail. Now, normally, those are not long jail sentences, but that's not necessarily, the case. Normally they're not long because no one has money. You know, the judge says, you owe $10,000 in child support, but he's working a minimum wage job. The judge might put him in jail until he comes up with $300.
Okay.
Which could happen that day. He calls up his mom or something like that and gets $300. But
sure.
Let's say the guy's got a $20,000 car or a $20,000 bank account. The judge might say, hey, I'm going to put you in jail until you give us $5,000 or $7,000. If you have money, why aren't you giving it to her? That's what the order says. You have not been obeying the order.
Okay, sorry about the interruption on the phone call. We have Samantha on the phone, and you have some general questions for Attorney Brad Tangler.
Hey, Samantha, how are you?
I'm good. How are you?
What's going on?
Well, I guess my first question is I have been attempting to get child support from my son's father, who is on some sort of disability. And the judge has basically informed me that because he's disabled, I'm unable to collect any child support benefits.
Okay. I can give you some generalized information about that. First of all, if someone is on disability, it does make it more difficult to get child support because, number one, they're not getting a lot of money.
Right.
And secondly, it is impossible to attach their assets. And what I mean by that is this. If someone is employed at a job, say, I don't know, whatever, McDonald's or, Sunstrand or something like that, you can send out a notice to withhold, and that money immediately goes to the state disbursement unit and then is sent to you. In this case, you have to, even if there's a child support order set in place, you have to get the money from him, sending that money into the state disbursement unit, and he's probably not doing that. Is that the situation?
Right.
Okay.
They haven't even set an amount at any point in time. It's just been, if he gets a job, then you can come back to court.
If he gets a job, and the judge, and has there been any consideration taken into place about what kind of income he is getting right now?
No, basically, the judge told me that the type of disability he's on, that they can't force him to pay me anything out of that. But if he got a job, then it would be different. And the other part of it is that he's married, and they basically set it up to where he continues to get disability and stays home with the kids so that she works, and I can't touch that money.
Sure. That's one of the other issues with disability cases is that some disability cases cannot be subject to child support. However, arguments can be made that while someone is somewhat disabled, they're not completely disabled, meaning that while they cannot, say, engage in work that they did previously, i.e., be a teacher, they can get a job at McDonald's.
Right.
And in that kind of argument, obviously, it depends to a certain extent on the judge, but that's one of the arguments that can be made as well.
Right. Well, that was kind of the area that I was dabbling into, is if he's too disabled to even flip burgers at Burger King, then how is it you feel he's a good parental role model to be parenting a child, but he doesn't have it in him to flip burgers or anything?
Sure. Well,
You know.
and obviously those two issues are very different, whether or not someone... So
That's part of my, he's admitted that he won't get a job because then he has to pay child support and his wife can work and that's their money and I can't touch it. But it just seems kind of interestingly fishy.
Yeah. Well, what I suggest you do, this is kind of generalized information. This would be something you'd want to follow up with me or another attorney at an office to formulate some kind of strategy. These kinds of situations are complex, but I'm sorry, it's unfortunate that you're not getting any support at this time.
Right. All right. Well, thank you.
Thanks, Samantha.
Have a great day.
You too.
Okay, sorry about that phone interruption. Thank you, though, Samantha, for calling in. The next question I have for you is, this is sent from one of my friends as well. Can my current husband get health insurance through his company on kids who are not his?
That's a question that she would have to take up with the health insurance company itself.
Okay.
That would be a contractual thing. If the health insurance company allows that, because you're living in the same house together, then sure. If it doesn't, they say, well, they got to be biologically related to you, then not. But that sounds like it's a possibility that might be able to happen. It's going to cost more money, but ultimately that'll be the decision of the insurance company based on the contract that the insurance company has with her husband.
Okay. Well, there's your question. Okay, Brad, I appreciate that. Again, this is attorney Brad Tangler. He has a show here at Divorce Talk Radio. It's every Tuesday at 8 p.m. You can find out more on his website, which is what, Brad?
www.tanglerlaw.com.
And Tangler is spelled Tengler. Again, that's Tangler, Tengler. And he's definitely willing to talk to you and figure out different ways to help you with child support and custody and all kinds of good stuff. What all do you do at your law firm? It's not just custody.
80% of our practice is family practice. By family, divorce, child custody, visitation, adoption, guardianship, juvenile cases. We do other things as well, but that's the primary focus of what we do.
Sure. Do you have anything else you might want to mention? You also have a Facebook. Also, they can contact you through Facebook, or
they can contact us through Facebook. We're on Twitter,
wow.
And obviously our website. And I think next week we're going to be talking about child support in relationship to the Department of Healthcare and Family Services and how they help people get child support.
Okay. Now, let's just say, because obviously anybody can listen to this show or any show on RadfordCollegeRadio.com. Let's say somebody's in Elgin or somebody's in Springfield or whatever and is still in the state of Illinois. Can they still have you represent them or ask you a question then? Because as long as it's in the state of Illinois?
Well, absolutely. They can call our office.
Sure.
Come on in. Generally, if they're way downstate, it's probably not in their best interest to hire our firm, but I'd be glad to talk to them.
Okay, well, there you go. That's good. This is an interesting show. I learned some stuff. I don't have children, but it seems like there's a lot of different cases that come up. I'm sure you deal with
all kinds of cases. All kinds, man.
Yeah. Well, again, this is Divorce Talk Radio on RadfordCollegeRadio.com. If you missed the live show, you can always go back to our main web page here. If you look up, there's a little tab that says podcast. You click on that, and he has all his different shows. He's going to do one every week on two totally different questions and topics or whatever. And eventually what we're going to do is we're going to open up live phone calls, so where almost the whole interview is going to be questions from people asking general questions, and that way you can get some advice before you go drop $1 million and without knowing, all the different routes you may be able to take. So it's definitely a great show, and I think it's a cool idea that Brad came up with it.
And we just developed an app that can be downloaded through Google Play.
Oh, really?
It's soon going to be available on iTunes.
Wow.
So right now, people can go to my website, download the app, click on Google Play, the button that we have there on our website, and you can put it on your Android.
What are some things that are available then through this app?
Two things we have on the app are the podcasts that we produce on a weekly basis, as well as our written blog, which is updated. The written blog is updated probably twice a week, 3 times a week, and the podcasts come out on a weekly basis.
You just heard a phenomenal episode of Divorce Talk Radio. Listen to Divorce Talk Radio live on RockfordCollegeRadio.com, Tuesday evenings at 8 p.m. To hear more of Divorce Talk Radio shows, please visit RockfordCollegeRadio.com. To learn more information about attorney Brad Tangler, please visit TanglerLaw.com.